that. Otherwise, whatever is ready will take up.
Yes,
What is not ready will not take up. You said tomorrow,
Yes.
Yes, my lord.
Item
1
one,
and 6.
Item number 6, if this may be taken up on Friday, my lord.
Okay, we'll just mark it. Yes.
Your Worship, item 2 and 3, Your Worship. In fact, Your Worship, the question involved in these two writ petitions is pending before the Honorable Supreme Court. So, Zomo.
You have a case number?
Your Worship, in these two matters, the petitioners are working on contract basis under the respondents. And the respondents have taken a policy decision to outsource the services through GEM, Government E-Contract Portal. And if Your Lordship will see the Madras High Court decision, if I may take Your Lordship to page 22 of the judgment of the para 13. In para 13, page 22, the page number is at the bottom of the page. The page numbering is given at the bottom of the page, left-hand side.
What is the issue involved?
The same para 13, whether the 202 HKAs means housekeeping assistants employed on contract basis are entitled for regularization of their services. B, whether the policy decision taken by the respondent to engage contract staff through GEM portal by calling for tender would be valid in the light of the rules framed by appointment of railway servants under Article 309 of the Constitution of India. This is the same question involved in our case also. We have been working on contract basis for a number of years. Now the respondents have taken a decision to engage the staff through the GEM portal. So the same question is involved in this matter. The Madras High Court had dismissed the writ petition, but the Supreme Court has recently admitted the petition, the SLP, in 7187 of 2025, and this is the order issuing notice. So in my humble submission, Your Worship, is that since the issue involved in the present writ petitions is pending before the Supreme Court, the outcome of the SLP may kindly be awaited.
So we don't know when it is going to be considered for finally.
That, yes, it may take some time, Your Worship.
Will adjourn it for 4 weeks or 6
weeks.
weeks for the time?
6 weeks for the time.
What are the petitioners engaged as in this case, in your case?
In my case, Your Worship, in different capacities. Some are cooks, some are peons, some are drivers, some are even lecturers in different capacities.
Under?
Rippons.
Now, what about this item number 3? It says Havildar.
Yeah, he's a retired army man, so he was re-employed.
Oh, I see. Okay. Please write down. Mr. A.R. Malhotra, Learned Counsel for the petitioners, submits that the petitioners have been engaged in different capacities under RIPANS, R-I-P-A-N-S, RIPANS. And that instead of regularizing their service, the respondent authorities are intending to fill up the posts that they are occupying through GEM, G-E-M. To stop. The Learned Counsel submits that a similar issue arose before the Madras High Court. On the writ petition filed by Dakshin Railway Employees Union. Stop. Although the writ petition was dismissed by the High Court, on appeal filed before the Apex Court, the Apex Court has admitted the SLP. Full stop. He therefore submits that pending consideration of the SLP, the instant matter may be adjourned, since the outcome of the SLP would squarely cover the case of the petitioners. Full stop. In view of above, the writ petitions are deferred for 6 weeks.
I'm aware.
Stop liberty is granted to the petitioners to mention before the court as and when the SLP is disposed of. All right.
May I seek your lordship's indulgence in making a mention of an unlisted item, my lord? I have filed a writ petition last Thursday. There is an urgency in the matter, my lord. So if the matter may kindly be fixed tomorrow.
What is the matter?
It is regarding the unwarranted and illegal penalization of the petitioner, my lord. And the urgency is that there's a Mizoram Premier League Season 12 coming up this Thursday on the 21st, my lord.
Okay. And he's barred from playing.
My lord, he has been not only barred, but he has been...
Blacklisted.
Yes, my lord.
All right. There are similar other matters pending also?
Yes, that will be taken up today itself also.
Okay. All right. Tomorrow.
Oblige.
Motion, item 1.
May I please, Your Lordship?
Yes.
My lord, the petitioner is seeking a suitable direction for defreezing her bank account, which was freezed by the respondent's authority, my lord, without following due process of law. She has a bank account at Indasin Bank, Aizawl branch, my lord, and on 16/10/2024, she was informed by the respondent number 1 bank that her account has been freezed due to some suspicious transaction amounting to rupees 3 lakhs. And after that, my lord, if I may take a lordship to page number 23.
Suspicious transaction of about 3 lakhs.
Yes, my lord.
How much do you have in the account?
Prior to that, my lord, I have rupees 2 lakhs.
IndusInd Bank.
Yes, my lord.
And this is which branch? Aizawl branch.
Aizawl branch.
Who has given the direction for
The
freezing?
direction for this was given by the cybercrime unit of Tamil Nadu.
Tamil Nadu.
Yes, my lord. Despite the alleged suspicious transaction was amounting to rupees 3 lakhs, a sum of rupees 3 lakhs 6,107 rupees was marked as lien. And besides that, my lord, the entire transaction, debit transaction, was freezed. And after explaining the circumstances and approaching the respondent authority, my lord, the Tamil Nadu cybercrime unit had requested the bank official to this.
What you're saying is that despite this annexure 5,
Yes, my lord.
the bank is not defreezing your account.
Yes, my lord.
Have you approached the bank?
Yes, my lord, several occasions.
How?
Personally. As well as I have also gave legal notice to defreeze my account in pursuant to the communication made by the cybercrime unit. My lord, in a similarly situated situation, my lord, the High Court of Madras had also passed an order that in respondent's official concern therein to defreeze the bank account of the petitioner therein.
Please write down. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, who submits that the petitioner is a account holder at IndusInd Bank, Aizawl branch. And that pursuant to a notice received from the Superintendent of Police, Tamil Nadu, the bank has freezed the account of the petitioner bearing account number 100-173-486028 with immediate effect, and the petitioner was communicated about the same on 16/10/2024, bracket annexure 1. Subsequently, the bank received another communication dated
7/11 on the right top corner.
This is a seal, isn't it? Or 7/11/2024 from Cybercrime Police Station, Tamil Nadu. You write like this, Cybercrime Police Station. After that, we just add one more line. Krishnagiri, Tamil Nadu. Asking the bank to defreeze the bank account of the petitioner. Stop. However, despite the same, and also despite the legal notice given by the petitioner to the bank has not defreezed her bank account, and therefore the petitioner is before this court. Stop. The learned counsel submits that the power to freeze the bank account can be exercised by invoking the provision of section 102 CRPC corresponding to section 106 of the BNSS. Stop. However, in the instant case, the respondent authorities did not invoke the said provision, and therefore they are liable to be directed to defreeze the petitioner's bank account. Next para. In view of above, issue notice of motion returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD due within 3 days. Number one, you can send by Dusty also.
Yes,
by
my lord.
Dusty.
Yes, my lord.
Additionally, the petitioner is permitted to serve notice to respondent number 1 by way of Dusty through the registry of this court within a week, and thereafter file an affidavit as proof of service. list the matter again after 4 weeks.
My lord, I have an interim prayer.
Issue notice on the interim prayer, returnable by 4 weeks.
Give your blessing.
Admission item 2.
My lord, we are ready to take up this matter, my lord. So, my lord, if we may be allowed to start after part 1, my lord. If we may be allowed to start after part 1, my lord. I mean, we are ready to take up this matter for disposal, my lord, today.
Okay. What is the subject?
My lord, this
Issue
matter is in relation to the post of a superintendent, my lord, in the NIT. So,
see.
my lord, our contention is that the respondent number 5, he is overaged. And so we are challenging the appointment of the respondent number 5.
NIT.
NIT, my lord.
I see. We'll do one thing, we'll take up the orders matters first,
Sir.
as I usually do, today also.
Yes,
Then after, we'll come up with the admission matters.
certainly, my lord. Much obliged.
Orders, item 7.
Yes, may I please, Your Lordship?
Yes.
And this is the bail application.
How many witnesses are remaining?
No more witnesses. This is at the stage of defense evidence.
Defense evidence.
Yes.
And how many, the applicant has been examined under 313?
Yes, Your Lordship.
He's been examined.
Last
When
week.
was that?
16.
16.
16, I believe. It was 16, yes.
16, that is on Saturday.
I'm sorry. Where's the last thing?
Today is 18th, isn't it? 16 means Saturday.
I believe it was 6th of this month.
6th of August.
6th of August.
6th of August,
Yes.
313.
313.
Then how many evidence do you have? How many witnesses do you have?
I have two, including me. I'll be having two
2 witnesses.
witnesses.
And when is that scheduled date?
It's today.
Today. I think your sole ground for asking bail is that you've been there incarcerated for quite some time.
Yes, Your Lordship.
And
also
last
I have-
time also, this aspect of the matter was taken into consideration by this court. But then keeping in view the developments that 1 or 2 prosecution witnesses remain, so it cannot be said that the trial will not stop, will not complete with, in the near future. So keeping that in mind, we had rejected your application.
Yes, Your Lordship.
Today, you tell me that 313 is over. You have 2 witnesses, yourself and another person.
The reason why we filed this application was, at the time of filing the application, the remaining 2 witnesses was not yet examined. But as soon as we filed, they dropped it and they started doing the 313. And immediately, normally what they do in the NDNPS trial court is that every after 15 days, when the prosecution witness was produced or today, the next after 15 days, it is production. It's only for production. That, however, due to filing of this application, they have rushed up and do it immediately.
That's good for you.
Yeah, that's good.
So we'll close this matter
Yes, Your Lordship,
if that development is happening.
if-
Because I have read the earlier order
yes,
passed by
yes,
this
yes,
court. That's why it has come before the same court.
Yes.
So I have read your application also, and because of the developments, I think we close the matter as of now.
Yes, Your Lordship.
Heard Mr. K. Rowland, learned counsel for the petitioner, and Ms. Mary L. Kyankte, learned additional public prosecutor for the state. Stop. This is the second time the applicant has filed bail application before this court. Stop. The earlier bail application being bail application number 27 of 2024 was disposed of by order dated 14/3/2024 by rejecting the application. Stop. Since as per the standing orders, pursuant to the direction of the Supreme Court, a rejected bail application has to be placed before the same court, the instant bail application has been laid before this court. We'll stop. Next para. Brief facts of the case is that the applicant was arrested on 28/7/2022 in connection with criminal trial number 1722 of 2022 under section 21 bracket C, read with section 29 of the NDNPS Act. Stop. The projected case of the petitioner / applicant is that his arrest was on account of recovery of 2.085 kilograms of suspected heroin packed in 156 numbers of polythenes of different color, which was recovered from one Tata Harrier vehicle bearing registration number TR01 BQ 0507. The applicant has been kept in custody since the day of his arrest. And since the trial is not likely to be completed in the near future, the applicant should be released on bail. Full stop. In the earlier bail application, this court had also considered this aspect of the matter. And keeping into consideration that the recovered amount is a commercial quantity and that out of the 10 prosecution witnesses, half of them have already been examined, this court declined to grant bail to the applicant. Next para. The instant second bail application has also been filed on the ground that two of the prosecution witnesses have not been examined despite passage of more than 6 months. And therefore, bail should be granted on this ground. Full stop. Today, Mr. K. Rowland, Learned Counsel, submits that after the filing of the bail application on 23/7/2025, not only have the two remaining prosecution witnesses been dropped, but the applicant himself has been examined under 313 CRPC. What is the equivalent? BNSS, corresponding to section so-and-so of BNSS, and that the defense have cited the applicant and one more defense witness. To stop, the Learned Counsel submits that all these has happened within a short span of time after the filing of the bail application. Stop, having regard to the same, it only appears that it would be within a short span of time that the trial is going to be completed. Stop, considering the same. Court is not inclined to grant bail at this stage, and accordingly, this bail application stands rejected.
God bless.
Item 8.
May it please your
Yes.
lordship. Yes, my lord. Service of notice has been completed for both RFA and IA.
How many respondents are there?
Only one respondent, private respondent.
Are you appearing for the private respondent?
Yes, Lordship.
What is your submission?
Lordship, with regard to that IA,
IA.
yes, the applicant has met
My lord, IA
Stay
has also
application.
been filed. It is a stay application because this RFA arises out of an eviction suit in which the respondent has already filed an execution case. So for the stay of that execution case, I have filed IA along with it.
Okay, so IA is to be considered today?
Yes,
Lordship.
yes, your lordship.
yes,
Do you
Lordship.
have any objection to the
Yes,
stay?
Lordship, I'll object verbal.
You'll object verbally.
Yes, Lordship.
Why don't you file your objection in writing?
Lordship, I have very limited point, only 3 points, so I think it would be proper even in verbal also.
Okay, we'll hear the applicant
Yes,
first.
yes, your lordship.
Tell me.
Your lordship, in this RFA arises out of eviction suit, and in which in this eviction suit, the trial court has directed the appellant to vacate the suit land within 3 months. And this eviction suit was issued only based on a spot verification report submitted by a surveyor, without even adducing evidence, without even exhibiting this spot verification report, and without even a chance for cross-examination of the surveyor, the maker of the spot verification report. So, aggrieved by the impugn order, I have filed this appeal, and in the IA, I have prayed for stay of the impugn order in eviction suit as well as its consequential orders in execution suit. So my main grounds is that the suit property is where I run my business by the name Muakat Tire, and this suit property is under lock and key, only based on the verbal submission of the respondent in the trial court. Now, in this, I was not served a copy of the execution case also, and this has prejudiced me since I could not enjoy my peaceful possession of my land. So, due to this, irreparable harm and injury is caused to me, and if this stay application is not allowed, then the purpose of filing this appeal would be futile. So,
Appeal is filed against which order?
appeal is filed against the eviction order, the impugn order that is passed on 25th of
Eviction
July.
order is passed on which date?
25th July 2024.
And if that is the case, is not your appeal time barred?
No, my lord, it is not time barred.
How?
Because
You
I
can
have
file
filed
your
my
appeal
appeal.
anytime you want? Can you file appeal anytime you want?
No, my lord.
Then?
But I have already, I have filed my appeal on 21st of October already. Sorry, my lord. Condonation was also filed, IA, which is condoned.
A delay was
Yes.
condoned. So say that.
Sorry, my lord.
So delay was condoned
Yes, delay was condoned.
and the appeal is also admitted.
Yes, my lord.
Now, in addition to that, you have filed this stay.
Yes.
When was this stay
Correct.
filed?
This stay application was filed on
20 March.
Is this the first time you are appearing for the respondent?
No, Lordship, this is my second time.
Second time?
Yes.
Twenty-five, 7, then 31.
my lord. If I may, my lord.
Just a minute.
Yes.
Yes, tell me.
Yes. IA 206 was filed along with the RFA, in which delay of 49 days was condoned.
Oh, that's
Yes.
okay.
And
We're
then-
done with delay.
Okay.
Let us
And
concentrate
then-
on the stay.
Yes, IA 48 for stay application was filed on 20th of March. And then in So in that spot verification report, it was found that the LSU was sharing the same location. So since my LSU was at a younger age, my LSU was cancelled through that eviction suit. And then I was directed to vacate the sued land within 3 months. So that is the case. And then the respondent again had filed.
What is constructed in the sued land?
There is a building in which I have run my business, Muakataya. It's basically a shop.
Constructed by?
Constructed by me, because I have been in actual position since 1988.
Okay.
Yes.
You have
So-
been evicted.
Yes.
And you already, 1988, since 1988, you're in possession of the suit land.
Yes, yes.
And you've
yes, my
constructed a
lord.
building, you're doing some business there.
Yes.
And as per the directions of the eviction suit, you have been evicted from that
Yes,
place.
only based on that spot verification report, without even giving me the opportunity to adduce any evidence.
So against that eviction suit, you came in appeal before this court.
Yes, yes, my lord.
Is there any stay operating?
No, my lord. It's only status quo maintained as on March 20th.
No, that is in your IA.
Yes, yes, IA, for IA.
What
Other
about
than
in the
that, there is
appeal?
no other stay.
What about in the appeal? There's no order as such.
No, no, my lord.
Tell me one thing, your appeal was filed in December.
Yes, yes, my lord.
Why was it only taken up in June this year?
My lord, first, the condemnation was, hearing of the donation
Oh.
was conducted,
Oh.
and then next, execution was filed by the respondent. That's why I filed my IA 48, that stay application later on this year.
When was the delay condoned?
On 28th of March, 28th of March,
28.
yes.
Then after that, the matter was listed only in June.
Yes, yes, my lord.
Who was the plaintiff before the trial court? The opposite party. You're the
Yes.
plaintiff.
Yes, Lordship.
Yes. On what grounds have you filed this? IA for?
Yeah, my main grounds is that, your lord, my lord, when this execution case has been is filed by the respondent, I was not even served a copy of the execution case. And without even giving me a sufficient opportunity to appear in the execution case, only made on the verbal submission.
Your IA is for both? For stay of the main?
Yes, for stay of the main as well as the consequential order in execution suit.
My question is, why didn't you come for stay of the eviction suit in the first place? When judgment was rendered in last year in December,
Yes,
and your delay was condoned, like you said, in March.
yes.
Why don't you immediately press the court for stay of the impugned judgment.
Actually, in the last court, I have prayed for it. However, it was decided that it will be considered today only, so.
No, that was only on when? When was that? What is the date?
On 12th of June,
12th of June.
yes.
But your delay was condoned in the March already. For 3 months, you did not press for your IA.
Yes.
If you are indeed aggrieved with the
Yes,
eviction,
yes.
you
Yes.
should have not wasted time to
And-
come before the court.
Yes.
You
My
came
lord-
after some delay. Okay, delay
Yes.
condoned. Delay condoned in March,
Yes. Yes,
and
my
you are
lord.
pressing the matter only in June. And you are satisfied with that? The court saying that your application will be considered in the next court date, that is today in the month of August.
The thing is that, my lord, this suit property is not a residential building.
Maybe.
It is only for the purpose of running my business.
So what does the eviction order say?
The eviction order is at page 27.
You directed
If I
to
may-
vacate.
Yes.
No, that's not eviction order. Eviction order is at page
Yes, eviction
19.
order is actually
Page
at
19 onwards, operative at page 26.
Yes,
You are directed to vacate the suit land covered by LAC number so-and-so within 3 months.
yes.
Within 3 months. This order was passed in July.
25th July.
What did you do?
At that time, I was having difficulty finding advocates during that time. That reason is also been mentioned in my condonation application.
What sort of difficulty? I don't know. And then the eviction order came on 30th of January 25.
The execution, order in execution.
Execution,
yes.
correct. That is after around 6 months.
Yes, yes, my lord.
If you were in the same shoes of the opposite party, what would you do? Definitely, court says 3 months, you move away from this place within 3 months. You don't do that, then personally, the person will definitely file an execution case. So they file the execution case. You have to seek your remedy immediately, isn't it?
Yes, yes, my lord.
It appears that you're not so aggrieved with this.
We are aggrieved, my lord. Because the suit property is my main source of income. So,
Okay, let us come to your application. What is the ground taken by you? Starting from,
my ground is starts from page 7. Yes. With your lordship permission, if I may read out. For that, as soon as the impugned order dated 25/7/2024 in eviction suit was passed, the opposite party had filed an execution application number 171 of 2004 before the Learned Civil Judge Senior Division. The Learned Civil Judge Senior Division 2 Aizawl thereafter admitted the execution application and passed an order directing the suit property to be kept under lock and key until further order. B, for the applicant was not afforded sufficient opportunity by the Learned Civil Judge Aizawl in execution case before passing the impugned order dated 30th January 2025. The applicant herein was also not served a copy of the execution petition filed by the opposite party. Hence, this aspect of the matter has been overlooked by the Learned Civil Judge Aizawl before passing the impugned order dated 30th January 2025.
okay,
In fact,
just a minute.
yes,
That building of yours is under lock and key.
yes.
Since
madam.
when?
Since, I think it was February, early month of February.
February?
I'm not sure, Lordship, but yes, I think it's in the month of February.
Yes. C, for that the application would be greatly prejudiced if the impugned order dated 25/7/2024 in eviction suit and the consequential order dated 30th of January 2025 in execution case number 171 of 2004 is not stayed till the disposal of the connected appeal, inasmuch as the opposite party has denied the applicant of the enjoyment of her land and building covered under LSC number 37 of 1978. For that, unless the impugned order dated 25/7 in eviction suit and impugned order dated 30th January in execution is stayed, irreparable harm and injury will be caused to the applicant, and the purpose of filing the instant appeal will be rendered futile. E, for that there is a reasonable chance of the appeal being decided in favor of the applicant or the appellant on the appreciation of the materials available on record. Thus, this honorable court may be pleased to stay the impugned order in eviction suit and the impugned order in execution suit until disposal of the regular first appeal in the interest of justice. F, for that the applicant is the true and legal owner of the said land covered by LSC number 103-101, 01332 of 2008, and the said LSC is registered in her name. The land and building under the said LSC has been in possession of the applicant and her family. G, for that the learned civil judge, senior division, erred in law and in fact in passing the impugned order dated 25 July 2024 arising out of the eviction suit. H, for that the learned trial court was pleased to direct the Director, Land Revenue and Settlement Department for conducting spot verification on the prayer of the counsels for the party and in pursuance of the direction of the learned trial court, K. Lalchan Puya, surveyor, conducted spot verification in the presence of both parties along with their counsels and members of Zemabok Local Council, Aizol. Even though the spot verification report was submitted before the learned trial court on 7th of June 2024, the maker of the report was not examined by the learned trial court and no opportunity was given to the appellant or the defendant to cross-examine the said surveyor. I, for that the legal right of the appellant cannot be curtailed based on the spot verification report without adducing evidences. The appellant herein has also not accepted the spot verification report. In fact, the spot verification report cannot be considered as substantive evidence. J, for that the learned trial court could not have placed strong reliance on the spot verification report for adjudication of the case, as it has taken away the rights of the appellant to adduce evidence and to test the veracity of the findings made by the surveyor. K, for that the learned trial court has failed to satisfy itself that the determination of rights, title and interest of the disputed land covered by the LSCs of the parties herein is a sine qua non before directing the appellant to vacate the suit land covered by LSC 37 of 1978. In other words, the eviction suit against the appellant is not maintainable unless there was a decree in favor of the respondent or defendant with regard to the disputed land, either in a title suit or civil suit. Hence, it is kindly submitted that an eviction suit alone cannot give or take away the rights and interests of the parties with respect to title of the disputed land, and that too in the absence of any admissible evidences. And in point L, for that the learned trial court could not have relied upon the spot verification report as a substantive evidence, this honorable court in the case of Union of India versus and others versus Lel Ompuya and others in RFA number 29 of 2011 has held that unless the verification report dated 3/7/2007 is exhibited and the maker of the same is examined by the parties, the said survey report cannot have evidentiary value. And my lord, this judgment is annexed in Annexure 3 of my application. For that the learned trial court ought to have dismissed the eviction suit number 3 of 2023 at the threshold, inasmuch as the respondent or the plaintiff has failed to make a prayer for possession in their favor. Hence, this aspect of the matter has not been taken into consideration by the learned trial court. And for that, the learned trial court has completely overlooked the fact that the respondent or the plaintiff was not confident about the legality of her ownership over the land covered by LSC number 37 in as much as she has sought for an order to be declared as the legal and rightful owner of LSC number 37 of 1978. In fact, the learned trial court has failed to frame any issues with regard to the overlapping of the two LSCs before passing the impugned order dated 25/7/2024 in eviction suit. And then for that, the trial court has exceeded its jurisdiction in cancelling the LSC number 332 of 2008 when there was no prayer made by the respondent or the plaintiff in the eviction suit or any other proceedings. The trial court could not have passed the impugned order of eviction suit when the issue of title to the property is yet to be decided by way of evidence and the applicable laws. Further, the learned trial court should have satisfied itself that the respondent or the plaintiff has not sought for possession in the reliefs claimed by them in eviction suit number 3 of 2023. Hence, this clearly shows that the impugned order dated 25/7 of 2024 should have not been passed against the present appellant. P, for that the learned trial court erred in cancelling the LSC number 332 of 2008 abruptly without affording any opportunities to the appellant to adduce evidences and to cross-examine the surveyor who had conducted the spot verification of the disputed lands. Hence, this has completely abridged and take away the legal rights of the appellant. Q, for that the eviction number 3 of 2023 could not have been adjudicated in the absence of the Land Revenue and Settlement Department inasmuch as they are the land issuing authority in the state of Mizoram. The learned trial court could not have straight away cancelled the LSC 332 of 2008 without coming to a conclusion that the same was illegally issued or does not conform with the provisions of law. In fact, the power of cancelling of allotment of rights over land is provided in Section 33 of the Mizoram Land Revenue Act 2013, and which power is vested to the collector or the settlement officer or the assistant settlement officer or any other revenue authority on grounds enumerated therein. R, for that the impugned order dated 25/7/2024 is perverse, devoid of reasoning, and suffers from legal infirmities. In a review of the matter, the impugned order dated 25/7/2024 in eviction suit number 3 of 2023 is liable to be set aside and quashed. That is my grounds for the application, my lord. Yes, pardon, my lord?
Yeah, grounds for stay is quite many of them. It's like grounds for appeal.
Yes.
Huh?
I have both incorporated
what-
in my appeal as well as in my application.
What are the two LLCs involved? One is 37.
One is 37, that is the LSC of the respondent.
Respondent.
Yes.
And yours is,
And mine is LSC number 332 of 2008.
Okay,
So,
this is 2008.
yes. So only because of that, and since the surveyor has found that the LSC have shared the same location, and since mine is
Okay,
younger,
What is the original LSC? 332 of 2008. What is the origin?
a cadastral survey was conducted in the year 2008, around 2005 to 6, sorry. And in that, I was residing in that place. So LSC was issued to me on 2008.
And you're residing
Through
since when? You're residing since
Actual
when?
possession was from 1988.
1988. Where is the location?
Zemabok.
Yes, opposite party.
Yes. Lordship, as I have already said, I have a very limited point, only 3 points. And my first point is that, as my learned friend had mentioned, that trial court had issued order on dated 25/7/2024 in that eviction suit number 3 of 2024. However, without reviewing that order, they directly made an appeal before this honorable court, which is the connected RFA 48 of 2024 on dated 12 December 2024. And during that time, they doesn't make any application for stay of the trial court order. And also, as per the trial court order, they doesn't vacate their building within the prescribed period. So we have filed execution case before the trial court on November 2024, which is actually 1 month before they file their connected appeal, Lordship. And Even though,
Did you serve a copy of the execution?
yes, Lordship, we have, sir.
When?
Here is also the trial court first order, if I may.
When
say.
did you serve?
Lordship, I cannot explain the exact date, but we have surely served the copy.
No, that is the controversy. You see, the applicant says that we are not aware about the execution application.
Lordship,
And you say that we have served a copy.
yes, with your permission, may I submit the trial court order of dated 7/11?
What is written there?
It is written in
Please read it. Date of the order.
order dated 31/20/25. That is the execution case order, Lordship. In that order, point number 4, may I read, Lordship?
Yes.
Today is fixed for submission of WO and service report. Accordingly, the Land Council for the degree holder submitted summon return duly received by the judgment debtor. Trial court also clearly recorded that we have served summon. Here is also.
Yes. What do you say, madam? What do you say?
Yes, in that regard, the summon was served only at a later stage, I believe, because.
No,
during the
Lordship, not later stage. If we submit the later stage, the court would clearly mention here in the trial court order.
If there could be a documentary evidence on the exact date of the receipt.
Lordship, here is the trial court order, if I may submit. And may I, Lordship?
What is this? This looks like all in one order.
That is true.
Paragraph number 1 says, this is an application filed by so-and-so.
Yes, that is.
No, but
Yes.
just listen, please listen.
Yes, Lordship.
That's paragraph number 1 says, this is an application filed by so-and-so. Paragraph 2 says, admit, registered. Number 3 says, decree holder is present, judgment debtor is absent. Without cause, despite summons duly returned served. So, this was the first order.
Yes,
When was
Lordship.
the summons served? By which order was summons served?
Trial court had directed us to submit the summon by us, so I myself has many times went to the applicant house for service summons, Lordship.
On the first day itself, how do you say that parties are not present, are not appearing? Unless the court issues notice, how do you serve someone in advance? And on the first day, you come and appear before the court and say that their party is absent. Will it be fair? And it says today is fixed for WO again. Everything is happening in one day.
Lordship, that is maybe I'm not bringing the first order. Maybe that is the second time order, Lordship.
We'll do one thing.
Sincere apology.
We'll call for the execution file.
Yes, Lordship.
Let us see.
Yes.
Heard, Miss,
H. Lal Rausangi.
sorry?
H. Lal Rausangi.
H. Lal Rausangi, learned counsel for the applicant, who submits that by filing this application, the applicant seeks stay of the order dated 25/7/2024, passed by the Court of Civil Judge, Senior Division 2, Aizawl, in execution suit number 3 of 2023, and also stay of the order dated 31/2025, issued by the same court in execution number 171 of 2024, arising out of the eviction suit. Your good name?
K. Kamtian Manga.
Mr. K. Kham Thian Manga, Learned Counsel, appears for the sole respondent. And therefore, notice is complete. Registry to requisition. The LCR of both eviction suit number 3 of 2023 as well as execution case number 171 of 2024 from the Court of Civil Judge, Senior Division 2, I-Zone. And list the matter again on receipt of the same.
Thank you, my lord.
Let's
In the Manta, the name is out here, okay? It's a red flag. Red flag you'll find out. Yes. Next case.
My lord,
Item 9, sorry.
Yes.
my lord, this is bail application filed by the petitioner. The petitioner, along with co-accused Ken Dautung, was arrested on 26/3/2023 in
Will issue notice?
Yes,
Who's there? Heard, mister? Your good name?
Laltan Puya.
Heard, Mr. Lal Chanpuya, learned counsel for the applicant, who submits that by filing this application under section 483 BNSS, read with section 37 of the NDNPS Act. The applicant seeks bail. To stop, he submits that the petitioner was arrested on 26/3/2023 in connection with seizure of 353 grams of suspected heroin. And he has been charged under section 21C 2023. No, please, I'll repeat again. Under section 21(C)/23/25 of the NDNPS Act. To stop, the earlier bail application submitted by the petitioner, that is bail application number 69 of 2025, before the trial court, was rejected by the trial court, and also bail application number 63 of 2023. How can it be 2023?
My lord, only bail application was filed before the learned trial court.
Before this court, did you file anything?
No, my lord.
Then what is this order which is available here? Bail application 63 of 2023.
Page number 76 is bail application 69 of 25.
Please tell me, have you approached this court, the High Court, before?
No, my lord. This is my first time.
First time, okay. Issue notice returnable by so-and-so. When?
Anytime, Your Lordship. Anytime.
Next Monday, if possible. 25 or 26.
Returnable by 26/8/2025. Ms. Mary L. Kiangte, learned additional public prosecutor, appears for the state, and therefore notice is complete. Petitioner shall submit requisite copies of the, shall furnish requisite copies of the bail application to the learned additional PP. if not already done.
Obliged.
Item 10.
My Lord,
Yes.
in this matter there are 3 IS, and this IS 61 of 25 is for condoning the delay, and notice was issued, and the respondent number 1 is represented, and I have taken steps upon the respondent number 2 as well, my Lord. However, there is no return of ID card, but I have taken steps by way of Dusty also, my Lord, and affidavit with regard to that has been submitted, my Lord, with respect to respondent number 2.
How many respondents are there?
1 and 2, my Lord.
1 and 2. 1 is appearing. Mr. Victor, you are there?
Yes, my lord.
Respondent number 1. Then 2 you have served by Dusty.
My Lord.
Then has the court passed an order to that effect?
No, my Lord. So notice may be deemed complete, my Lord, upon the respondent number 2.
Dusty on the leave or on which?
On the IS 61, condonation.
61.
Yes.
What about 60?
60 is on the leave, my Lord.
Which
Leave.
one should come first?
I believe condonation should come first, my Lord.
Leave.
Leave has to come first.
Leave also, my Lord, because leave, my Lord, the notice was already issued on 29/4/2025. But in the previous court date, since the learned judge was of the view that this IS 61 should be taken up first, that is why 60.
No. I think the correct position is leave has to be taken first.
Yes, my Lord.
If you are permitted, then we look into condonation.
Yes.
And if delays condoned, we look into the appeal.
Yes, my
Like
Lord.
that.
On leave, my Lord, notice was already issued on 29/4/2025.
But any report?
And no, respondent number 1 is represented, but my Lord,
Number 2, what is the address?
the address is Van Louis.
You serve again
But-
by Dusty?
Yes, my Lord.
Please write, although...
My lord, if I may, before Your Lordship pass the order, the factual position, my lord, I have to address the factual position because the respondent number 2 herein is his wife.
Okay,
There
whatever
was-
it may be.
There was a suit.
The technical part has to be looked into. We are concerned with notice at this stage.
Yes, my lord.
So whether it's served or not, if it's served, then we'll look into that aspect.
I have already filed my written objection, my lord, because at this stage execution is pending, and this is only for prolonging, delaying the execution proceeding, my lord.
I understand.
I have enclosed one document, my lord, wherein I have enclosed one of the local council certificate acknowledging that both the respondent number 2 and applicant number 1 were still residing in the suit property at present.
My Lord, the fact of the case is that, my Lord, the respondent number 1 and the respondent number 2 are brothers and sisters. And I'm residing, the respondent number 2 is my ex-wife, my Lord. There are evidences which were adduced during the trial that the applicant, the present applicant and the respondent number 2.
No, 1 and 2 are brother sisters.
Yes, my Lord.
And
and-
you are the third party appellant.
Yes, my Lord.
You are the ex-husband of respondent
Ex-husband
number
of
2.
respondent number 2, my Lord.
Respondent number
What
2.
happened is that, my Lord, the respondent number 1 and 2, they have a dispute between them regarding the property left behind by their mother. And the right and title was given to the respondent number 1. And subsequent to that, he had filed
Anyway, see, we'll do one thing. You serve notice within 3 days.
Yes, my
We'll
lord.
post it again after 1 week.
my Lord.
You file an affidavit. Once we complete the formalities, we'll hear you
Yes, my
parties.
Lord. Yes.
Please write down. Although notice has been served upon respondent number 1 and 2 by way of registered posts and Dusty respectively in the condonation of delay application and pursuant to which Mr. Victor L. Ralte, learned counsel, appears for the respondent number 1, respondent number 2 has not been served notice in the application for leave to file appeal. Stop. Since the application for leave to file appeal has to be taken up first, the applicant shall serve notice to the respondent number 2 in the leave application within 3 days from today through the registry of this court, and thereafter file an affidavit as proof of service. List the matter again after a week.
Date may be fixed, my lord, if possible.
On Tuesday? On so-and-so, on Tuesday?
26th.
If possible on Monday, my lord. Tuesday I have some difficulty.
Okay, on 25th,
Oblige.
25th of August.
Submission, item 3.
Item 3. Huh? No, we'll go serially. We'll go serially. Anything to be done in item 3, matters to be heard.
My lord, I have not received any affidavit from the respondents. This is a matter of extreme urgency, my lord. However, I was just informed that I will be receiving the same today. So if your lordship will permit me a day to go through their affidavit and have the matter fixed tomorrow, my lord, along with the mentioned unlisted item, my lord.
Tomorrow.
Yes, my lord.
Oh, this is that
MFA.
that same subject.
Yes, my lord.
Yes, you are there.
Yes, my lord. We'll be filing the counter affidavit to the
Yeah,
IA.
file.
We will be filing
You'll be
today.
filing.
Yes, we have served.
Which
copy.
respondent number?
7 and 8.
7, 8.
Yes.
And you are for?
And Your Lordship, I'm for the respondent number 1 to 5. And Your Lordship, what I would like to mention is that in this writ petition, we are not the necessary party since
Okay.
the MFA is non-government authorities.
All right.
and
Then who is number 6?
6.
1 to 5, 7 and 8. 6 remains.
Yes, 6 is the AIFF, my lord.
Anyone representing?
Not as of now, my lord.
Notice is
However,
complete.
we have no, these are not the necessary party, my lord.
Then why did you make them a party then if they are not necessary?
They are necessary, but, my lord, but our grievances is against the respondent number 7 and 8, my lord. Mainly 7 and 8.
Please write down Miss Valentina Laldinpui is item number 3. Valentina Laldinpui, learned counsel for the, you have received advance copy.
No, my lord.
You said that I'll go through, then I'll have it
Yes,
tomorrow.
the counsel for the respondent 7 and 8 said, informed me that she will be giving me after this court, my lord.
Okay, you cancel, okay, you write like this, Miss Valentina Laldinpui, learned counsel appears for the petition as, stop. Miss Lal Sakifa Nai, learned counsel appearing for respondent numbers 7 and 8, submits that she will be filing counter affidavit of the said respondents during the course of the day. Stop. Miss Vanesiami, learned government advocate, submits that she represents respondent numbers 1 to 5, who are basically pro forma respondents. Who stop. Since urgency has been expressed by the learned counsel for the petitioner, let the matter be listed again tomorrow.
Tomorrow, my lord.
The respondent numbers 7 and 8 to file the affidavit in the meantime. All right.
Oblige.
Item 4.
My lord, in this matter, I have filed affidavit to ascertain the correct address of the respondent number 3. On the last occasion, the learned CGC submitted that the letter sent to the respondent number 3 was returned unserved. So I had clarified that, Your Lordship, by filing an affidavit, this respondent number 3 is now functioning under the respondent number 5. Because respondent number 3 is the NF Railway in Bairabi, which was earlier headed by Deputy Chief Engineer. But now Bairabi NF Railway is functioning under Aizol, Deputy Chief Engineer, NF Railway Aizol. So it would be correct if letter is sent again to respondent number 5.
3 is functioning under 5,
Yes, my lord.
or 5 is functioning under 3.
No, 3 is functioning under 5 now, my lord. I have clarified by through sending representative to the Bairabi office.
But both of them are the same rank, deputy chief engineer.
Yes, now Bairabi is functioning under the executive engineer only, my lord. No longer there, deputy chief engineer.
Then why do you make the nomenclature as deputy chief engineer?
At the time of filing of the writ petition, my lord.
So you
there
amend
was.
it. You
Yes.
amend it now.
Yes, my lord, I'll amend it.
Because deputy chief engineer working under deputy chief engineer, it doesn't sound proper.
If I'm allowed to,
Mr. Bilal Ram Enga, please write down. Mr. Bilal Ram Enga, learned counsel for the petitioners, submits that deputy chief engineer, comma, CON-Roman 1 / Bairabi at Silchar, comma, NF Railway, Tarapur Silchar, is now functioning under the
executive engineer.
executive engineer. Is no longer the authority, and the authority in place is the executive engineer. What is the full form?
Executive engineer.
Full stop. He therefore submits that respondent number 3 will now have to be the executive engineer concerned. Considering the submission, the petitioner shall file an application seeking amendment of the arrayed respondent. You file it?
Yes, your lordship. Much obliged.
Item 5.
My lord, in this case, the respondent number 1 is yet to file their affidavit.
My lord, I may not be filing my affidavit because since till date, I didn't receive any proper instruction in this regard.
Only because of that? No, it's not that they have instructed you that no affidavit is not required. It is that since you have not received anything, you're saying that will not be filing.
Because even we are given last chance in the last occasion, my lord. The same has been informed to them.
When was the last chance given?
Your lordship may see 29/5 order.
29/5.
Yeah.
There is no such order.
1/7/2025, my lord.
Oh. Maybe I have not updated my note sheet.
1/7.
Chance, last chance.
1/7.
Please write. Parties are represented by the respective councils. Full stop. On 1/7/2025, learned CGC was given one last chance to file affidavit on behalf of respondent number 1. Full stop. It is, however, seen that affidavit in opposition has not been filed. Under this circumstance, matter will have to proceed. Accordingly, registry to list the matter for admission after 2 weeks.
Obliged.
What is this FAO? Oh.
Item 6.
My lord, by filing this FAO, we are challenging the order, the temporary injunction order dated 03/07/2025, passing MA number 50 of 2025 arising out of civil suit number 6 of 2025.
Okay. Heard, Mr.
My Lord, if I may, along with this appeal, we have filed one IA, that is stay of the operation of this impugned
Notice
order.
will go at this stage only. Heard, Mr. J.H. Ramney Moya, learned counsel, is in the cost list. J.H. Ramney Moya, learned counsel for the appellant, who submits that by filing this appeal under Order 43, Rule 1, bracket small r, CPC, read with Section 17, bracket 2, bracket small b of the Mizoram Civil Codes Act 2005. The appellant has challenged the order dated 3/7/2025, passed by whom?
The Civil Judge Senior Division 4.
Where is the order?
It is in just after the
Passed by
indexed.
the Court of Civil Judge, Senior Division 4, Aizawl, in CMA number 50 of 2025, arising out of civil suit number 6 of 2025. Issue notice to the sole respondent, returnable by 3 weeks. Appellant to take steps for service of notice by registered post with ADD within 3 days. Then in the IA, you write, heard Mr. So-and-so, same thing. Learned counsel for the applicant, who submits that by filing this application, the applicant prays for stay of the order dated 3/7/2025, passed by so-and-so, same party. Issue notice, 3 weeks. Okay.
If I may, my Lord, if an interim stay...
No,
may
we'll
be-
issue notice only at this stage. So we'll come back for item 2. I'll just take a break for 5 minutes.